Good morning. My name is Denver Edwards. I'm a principal at Bressler, Amory, and Ross in the Financial Institutions Group. My practice focuses primarily on counseling clients on financial services matters, regulatory investigations and litigation, internal investigation, and also advising clients on information security and data privacy issues. Information security has become an increasing part of our lexicon, whether it's cybersecurity, information security, data privacy, it all sort of means the same thing. It's created a sense of heightened anxiety among business lawyers and their business clients because we know that weak information security may pose potentially an existential threat to a company's survival. So today I want to talk to you about two things. First, what are some strategies that companies are using to manage cybersecurity risks among vendor relationships? And secondly, what steps can in-house counsel take when preparing contracts that will help them manage vendor risks? Before getting into the nitty-gritty, I'd like to give some context around why cybersecurity is important, why it's top of mind. I know many of you have heard this speech before, but it's important to have some context. Breaches have become ubiquitous, and it really doesn't matter whether you're a large company, a small company, or somewhere in between, nor does it matter what industry you happen to be in. The aim of a hacker is to infiltrate your system, steal the digital asset, and monetize that digital assets. We know that hackers use the information for corporate espionage, to commit financial crimes, as well as to commit identity theft. We also know that regulators have focused attention on information security, and that has caused regulated entities to implement processes and procedures to minimize breaches and also to reduce the impact of those breaches. For example, one thing we know is that where there has been the appointment of a chief privacy officer, the cost per record when a breach does occur has decreased by $3. We know that the deployment of sophisticated analytics has caused the price of each stolen record when a breach occurs to decrease by $7. And so the regulatory emphasis has been beneficial in many respects. Nevertheless, data breaches continue to occur almost on a daily basis. In 2017 alone, there were 1,579 reported breaches, and that's about a 45% increase over 2016. The average cost of a data breach is approximately $7.5 million in the United States, also a 5% increase over 2016. We know that those figures are primarily just the hard cost. There's soft costs or indirect costs as well. There's market capitalization that declines. There's reputation injury. There's also customer morale that declines. And finally, most importantly, or equally importantly, is customer churn. Why is this happening? One primary reason why this happens, I think, is because we are more interconnected now than ever from a business perspective. What happens when you have this greater degree of interconnectivity is that the hackers have a broader surface area at which to attack. Now, we know that with the spotlight by the regulators that most companies have pretty robust information security policies and procedures at this point. However, your vendor might not have as much of a robust information security policy or procedure, and therefore hackers are now going through the vendor and leveraging that connection to get to the primary institution that is more of a deep pocket. What's interesting about that situation is a recent study showed that 44% of the respondents to the study determined that companies are not paying sufficient attention to managing vendor risks. So what are some of the strategies that companies are following these days to address vendor management and vendor risk? First and foremost, at a high level, I think it's important for lawyers to talk to their business clients or their in-house clients about the legal requirements of the industry in which the company operates, and to discuss the importance of an enterprise-wide approach to information security. In addition to that, when dealing with major vendors, I think it's important for lawyers to participate in or facilitate a cross-functional team to communicate with the vendor about the importance of information security. And what we know about diversity is that many perspective leads to a stronger result. The cross-functional team also functions the same way, because the CFO, the chief marketing officer, the chief risk officer, the chief HR professional, they have different ways of looking at information security. And I think it's important that the vendors recognize the impact that it could have on the organization. The second strategy is to present evidence to the vendor that shows that information security is a competitive advantage. There's a cost associated with it, but it's a competitive advantage to be more secure. And what we know is that individuals value security. Companies are made up of individuals and operate in very much the same way. Companies also see it as a competitive advantage to work with companies or counterparts that have robust security. The third strategy is a case-based study to show or to marshal evidence to show the impact that data breaches have on an organization, to show how the breaches occurred, particularly in instances where the breaches occurred through a vendor arrangement, and then also show the impact on the organization. The primary institution that people talk about in this situation is Target. We know that Target was breached not directly, but because the hackers got through the HVAC vendor, which controlled all the Target stores. And once they were in the HVAC vendor, they were then able to go into Target's network, and then from there to commit the fraud that they did. Fourth, and I think probably one of the strongest thing, is to motivate or coerce vendors to change their behavior regarding information security. And that comes down to just basic contracting. Either you improve your information security policies and procedures to protect the company's data, or we will no longer do business with you. So those are four strategies that I think have been used somewhat regularly. I'm sure that there are more, but I think those are some interesting ones and some good ones to start out with. Now I'd like to talk on a more practical level about what in-house lawyers can do to protect their company's digital assets while engaged in the contracting process. So first of all, we assume that your company has a robust information security policy and procedure that covers the entire enterprise, including procurement and contracting. We also assume here that your counterparty also has an information security policy and procedure, and now we're just getting down to making the arrangements as tight as possible. And by the way, if you hear some banging while I'm speaking, on the floor below me they're doing some construction, and I apologize for the distraction. So first off, the first element, I think, is to have an information security compliance provision in the contract, which includes reps and warranties regarding regulatory compliance and also compliance with industry standards related to information security events. It's important to ensure that the reps and warranties are not vague and that they meet your organization's requirements and particularized needs. The second thing I think is important to have in the contract is the standard of care. In-house counsel should ensure that the standard of care is equal to or stronger than its own information security and privacy policies and practices, and that the requirements of applicable law and industry standards are also met and meet your organization's guidelines and particular needs as well. The third element that I think should be in your contract involves access management. And it's important to limit the vendor's access to sensitive data and systems as is necessary to complete the business requirements that are at stake. 4, I think it's important to limit disclosures. Now, we know that companies sometimes collect data and share the data with third parties. I think it's very important to limit such disclosures to third parties without your expressed consent. And not only is it important to require that your vendor get your express consent, but the vendor's subcontractors should be required to adhere to the same privacy and information security standards and oversight and management as the vendor is required to adhere to. I think that's a very critical element of a contract to provide or to stop information seepage beyond your control. Next, I think audit rights. Audit rights are critically important. It's important to ensure that the organization, your organization, can audit or otherwise access and review a vendor's privacy and information security practice based upon the risks exposure of that data would pose to your organization. I think this is a very critical point as well. It's important to be able to get access to the information to make sure that what they have in their contract is actually what's being done. I think depending on the sensitivity of the information that you've shared with your vendor will determine how frequent you have an audit and also the depth of the audit. So, for example, if the information that you share is not particularly sensitive, but important nonetheless, I think you can rely upon the company or the vendor to do its own audit and to make a representation or certification to you. However, with more sensitive data, with critical data, for example, trading algorithms and things of that nature, I think it's important to have perhaps a third party conduct the audit and to have a particularized type of audit done so that you can ensure that your information is adequately protected. Next, I think it's important to have a security incident procedure. And what that means is that it's necessary, or you should have in your contract, that the vendor will report a security incident that impacts personal data or confidential, significant confidential or sensitive organizational information that may impact its network or its computer systems. Report that information within 24 hours. I know in some other situations, such as in New York, the Department of Financial Services requires you to report a security incident within 72 hours. The GDPR also requires you to report within 72 hours. I think you are allowed to set whatever limits you want, and a 24-hour turnaround is perhaps reasonable, but certainly subject to negotiation. Next, I think it's cost allocation. And this is really important because breaches are likely to happen. And as I mentioned at the outset, the cost is roughly running at $7.5 million to remediate a breach. So cost allocation is important, and many aspects of a breach are not covered by insurance. So it's important to allocate costs and responsibilities between the parties for handling a security incident. And some of the elements of that cost allocation would include indemnification for costs and expenses for non-compliance. Another element would include insurance, including specific policy limits related to the vendor and also its subcontractor. And again, this is one of the things you want to audit to make sure that these policies are in place so that if there is an incident, you're covered. Another element of the cost allocation, I think, is for regulatory penalties and liabilities if a vendor is determined not to have complied with information security practices per law or per industry standard. I think it's important to ensure that that the company is protected financially. And the final element, and I'm sure there are more, but the final element that I'll talk about here is in the event that there is a breach, you want to make sure that your company has control over the defense. So not only control over the defense, but also control over settlement decisions, control over the selection of counsel. I think it's important so that you can extract yourself from the situation as quickly as possible, or if not extract yourself, make sure the settlement is not as adverse to you as it otherwise might be if someone else controlled the situation. Finally, I think it's important to have a termination provision that includes disposal of the confidential information. It's important to establish what an event of default would be in the context of information security, and once those events of defaults have occurred, what the termination provision is, and what the steps to termination would look like, and the cost of termination, what would that look like? Finally, with respect to termination, obviously you've given information to a third party. Now, to close the loop, you have to get that information back. I think it's important to include how the information would be returned to your company. And if the information cannot be returned without undue hardship, there has to be procedures in place to terminate or destroy that information, and then some sort of certification process on the back end to make sure that has in fact been done. So those are some 8 things that I think a law department can do when doing some contracting to prevent or to minimize vendor risk as it relates to information security. There is one additional point, however. I think that there are instances, and I don't know of many, but I think there are instances where there's a decentralized contracting process within companies. So the business units can negotiate contracts between each other, and the lawyers are really not that involved. I think in those instances, it's important for the law department to ensure that the company has a general standard language about information security that will be included in all contracts, including contracts that are negotiated in a decentralized way. And that to have a requirement that that language, that standardized language that is going to occur or be included in all contracts can only be changed with the approval of a member of senior management. I think that's really important to make sure that there are no rogue employees who go off and negotiate away information security provisions that could ultimately hurt the company. So that covers my presentation today regarding vendor management and mitigation of vendor risk. I think that cybersecurity concerns are very important. They've created a lot of anxiety, and the thing to remember is that cybersecurity, information security, is really about theft of information that is beneficial to your company. And these are just some steps that can be used to minimize a data privacy situation that's adverse to your company. These are not going to stop a breach from happening, but they can certainly minimize a breach from happening or the impact of a breach once that has occurred. Thank you.